There is a dollar amount written into the Bill of Rights, $20. It sits in the Seventh Amendment, and it draws the line for one of your oldest rights, the right to have a jury rather than a judge decide a civil lawsuit. In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. $20. Cross that threshold, and the jury right attaches. And here is the first strange thing about it: that number has never once been changed. Not in more than 2 centuries. In 1791, $20 was real money, weeks of an ordinary laborer's wages, a serious sum worth arguing over. Today it is lunch, and that is only the first strange thing. Here is the second. You would assume a right this fundamental, trial by jury, the very thing the Declaration of Independence accused the king of stripping away, would apply everywhere, in every courtroom in America. It does not. The Seventh Amendment governs federal court, and only federal court. If you are sued in state court, where the overwhelming majority of civil cases in this country are actually filed and tried, the Seventh Amendment gives you nothing. Whatever civil jury right you have in that building comes from your state's own constitution, not from the federal one. So the question for this primer is exactly the one the amendment's own oddities force on us. The Seventh guarantees a civil jury for any dispute worth more than $20. So why was that number never updated, and why doesn't it bind the states? This is Do It for the Case Law. Doctrine Deep Dives, Season 0, The Amendments, one at a time, one sharpest gap each. Today, the 7th. Start with why this amendment exists at all, because it is not a minor bit of housekeeping. To the founding generation, the civil jury was a structural safeguard, a way for ordinary citizens to stand between an individual and the power of a judge, and behind the judge, the government. When the unamended Constitution came out for ratification, it protected the criminal jury in Article 3 but said nothing about the jury in civil cases, and that silence became one of the anti-federalists' loudest complaints. The absence of a civil jury guarantee was cited over and over as a reason to distrust the whole document. The Seventh Amendment was the answer to that complaint. So this is a provision that was, in its moment, a headline demand of the people who insisted there be a Bill of Rights in the first place. The Seventh Amendment is short, and it does 2 distinct things. The first clause is the one people half remember in suits at common law, where the value in controversy exceeds $20. The right of trial by jury shall be preserved. Look hard at that verb, preserved. Not created, not granted. Preserved. The amendment is not inventing the civil jury out of nothing. It is taking the jury that already existed at English common law in 1791 and freezing it in place, forbidding Congress from stripping it out of the new federal courts. That backward-looking word is going to matter for the whole rest of this episode, because it means the content of the right, what a jury even is, gets defined by reference to what a jury was more than 200 years ago. The second clause is the one almost nobody remembers, and it has a name, the Re-examination Clause. It says that no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. In plain speech, once a jury has found a fact, a judge is not free to throw out that finding and substitute his own view of the evidence. The jury's fact-finding is walled off from judicial second-guessing, except through the narrow, pre-existing channels the common law already recognized. Things like an ordinary motion for a new trial. So the amendment does 2 things in sequence. It hands you a jury for your civil case, and then it fences that jury's factual verdict off from being quietly overridden by the judge. Get the jury keep what the jury found. There is one more phrase in that first clause, doing quiet work, that most people skim right past suits at common law. The founders' generation drew a hard line between 2 kinds of civil case. There were suits at law, the classic claim for money damages, one party suing another over a debt, a broken contract, an injury, and those came with a jury. And there were suits in equity, where you were not asking for money but for a court's order, an injunction, an accounting, the kind of tailored remedy only a judge sitting in conscience could fashion, and those did not carry a jury at all. The Seventh Amendment preserves the jury only for the first kind. So the right is bounded from the very start, not just by a dollar figure, but by that ancient line between law and equity.
And it attaches to the damages suit, and not to the case where you are asking a judge to order somebody to do, or to stop doing, something.
Before we get to the limits, that second clause deserves a case, because the Re-examination Clause is the one part of this amendment that has actually stopped a judge cold. And what it left behind is one of the strangest rules in American procedure. In 1935, the court decided Dimmick versus Sheet. The facts are small. A car accident in Massachusetts. A jury found for the injured plaintiff and awarded $500. The plaintiff thought that was far too little and moved for a new trial. The trial judge agreed the award was inadequate, and then, instead of ordering a new trial, made the defendant an offer. The motion is denied if you consent to raising the damages to $1,500. The defendant consented. And here is the court's own description of the plaintiff's role in that arrangement, verbatim. His consent was neither required nor given. That practice has a name. It is called additur, and the Supreme Court held it unconstitutional. Watch the method, because it is the same method that runs this whole amendment, verbatim. In order to ascertain the scope and meaning of the Seventh Amendment, resort must be had to the appropriate rules of the common law established at the time of the adoption of that constitutional provision in 1791. And what the court found when it went and looked, verbatim, a careful examination of the English reports prior to that time fails to disclose any authoritative decision sustaining the power of an English court to increase, either absolutely or conditionally, the amount fixed by the verdict of a jury in an action at law. Now hold on to that, because the mirror image is perfectly legal. A judge who thinks a verdict is too big may tell the plaintiff, "I will order a new trial unless you give up the excess." That is called remittiture, and it survives. Here is how the court distinguished them. Verbatim, the remittiture has the effect of merely lopping off an excrescence. But if the verdict is too small, an increase by the court is a bald addition of something which in no sense can be said to be included in the verdict. So the rule you actually live under is this. A federal judge may tell you your jury was too generous and squeeze the number down. A federal judge may not tell you your jury was too stingy and top it up. Same clause, same jury, opposite directions, and the entire difference rests on what English judges happen to have done before 1791. That is the promise. And read cold, it sounds unusually precise for a constitutional provision. A specific dollar figure, a specific right, bounded by a specific historical category. A specific protection for the verdict once it comes in. Now watch 3 quiet limits take all of that precision and turn it into something much softer than it looks. The first limit is about where the amendment even applies at all, and it is the largest of the 3. Across the 20th century, almost every provision of the Bill of Rights was incorporated, applied to the states through the 14th Amendment, so that the same federal guarantee that binds Washington also binds your state capital. Freedom of speech, the ban on unreasonable searches, the right to counsel, the protection against cruel and unusual punishment, all incorporated, all now binding on the states. The civil jury right of the 7th Amendment is one of the rare, stubborn holdouts. It was never incorporated, and the case that says so, plainly and early, is a 1916 decision with a mouthful of a name, Minneapolis and St. Railroad versus Bombolis. Bombolis came up out of a Minnesota state court. The underlying claim was federal and injured railroad workers suing under a federal statute, but it was being tried in state court, and Minnesota law at the time let a civil jury return a verdict without unanimity, by 5/6 of the jurors after they had deliberated a set number of hours. The railroad objected. This is a federal right we are being sued on, it argued, so the 7th Amendment ought to follow that federal right into the state courthouse and require a full common law jury, which is to say, a unanimous one. The Supreme Court rejected that argument flatly, and it did so in language that leaves no daylight. Here is the holding verbatim. The 7th Amendment applies only to proceedings in courts of the United States, and does not in any manner whatever govern or regulate trials by jury in state courts or the standards which must be applied concerning the same. And the court gave its reason in one clean line, that the first 10 amendments, including of course the 7th, are not concerned with state action and deal only with federal action. Sit with what that does. Even when the underlying right you are being sued under is itself federal, the 7th Amendment does not travel with it across the threshold into a state courtroom. The state is free to run its own jury rules, a smaller panel, a non-unanimous verdict, whatever the state's own law provides, and the federal civil jury guarantee has nothing whatever to say about it. And this is not some abandoned relic of 1916 that the modern court has forgotten. As recently as its major decision applying the right to keep and bear arms to the states, the Supreme Court paused to note that the 7th Amendment civil jury right is still one of the few guarantees that has never been incorporated. So the practical map is this. The grand promise of a jury of your peers in a civil case is a federal courthouse promise. Walk across the street to state court, where most lawsuits actually live and die, and as a matter of the federal constitution, it does not reach you. Make that concrete. 2 people can be injured in identical ways, sue over identical amounts, and end up with different rights to a jury for one reason only, which courthouse the case lands in. File in federal court, and the 7th Amendment is standing behind you. File the same dispute in state court, and the only civil jury right you can point to is whatever your particular state's constitution and statutes happen to give, which might be a full jury, might be a smaller one, might in some categories of case be no jury at all. Most states do protect a civil jury under their own law, and generously. But that is a favor from the state, not a command from the 7th Amendment. and a state remains free to draw those lines differently. The second limit is subtler, and it is about what you actually receive even in the federal court where the amendment does apply. Remember that word preserved? The right is the common law jury of 1791, and at common law, a jury meant 12 people, returning a unanimous verdict. 12. So you might reasonably assume the Seventh Amendment locks that in 12 jurors. No fewer. It does not. In 1973, in Colgrove v. Batten, the court looked at a federal trial court that had seated a 6-person jury in a civil case under a local rule and asked whether a panel half the historical size still counted as the trial by jury the amendment says shall be preserved. The court held that it did. Here is the holding, verbatim. We conclude that a jury of 6 satisfies the Seventh Amendment's guarantee of trial by jury in civil cases. Half the common law jury, and the guarantee is still, in the court's word, satisfied. Notice the move, because it is the same species of move you see all over this season. The text points backward to a fixed, concrete thing, the common law jury, 12 strong. But the court reads the guarantee functionally, rather than literally. What the amendment preserves, it says, is the substance of trial by jury, not every numerical feature of its 1791 form. And once jury is defined by its function instead of by that historical number, the concrete 12 becomes negotiable, and 6 will do the job. So the right you keep, even inside the federal court where the amendment applies with full force, is not quite the thing the 18th-century word described. Which brings us to the third limit, and it is the one that undoes the number this episode is named for. The $20 floor was put there to do real work, to keep genuinely trivial quarrels away from the expensive machinery of a jury trial. Because the figure was never indexed to inflation and never amended, it stopped functioning as a filter a very long time ago. That much is the familiar story. But here is the part that usually gets missed, and it matters more than the inflation point. The $20 line is not what actually decides whether your civil case gets a federal jury, because it is not what decides whether you are in federal court in the first place. That is a separate question, and it is answered by statute, not by the Seventh Amendment.
Right to see regardless of should be so for which course of fact it qualifies because it arises under federal law or federal question case. Congress imposes no dollar minimum whatsoever. A federal claim with $5 is still a federal case. But if it qualifies because the parties are citizens of different states, a diversity case, which is how an enormous share of ordinary contract and injury disputes reach federal court, Congress requires the amount in controversy to exceed $75,000. $75,000, not 20. And that figure is statutory, which means Congress has raised it before and can raise it again without touching the Constitution at all. So in the whole category of diversity cases, the Seventh Amendment's $20 threshold never binds anything. It is not the filter. It sits more than 3,000 times below the number that actually controls, and it is satisfied automatically the moment the real gate opens. The constitutional figure is not merely eroded by inflation, it is buried underneath a much larger statutory one. The most concrete, most quoted feature of the Seventh Amendment is the one part of it that decides nothing.
Those are the 3 limits inside the doctrine. There is a 4th thing happening outside it, and it may be the largest of all, because it never touches the text of the amendment at any point. The civil jury trial is disappearing. The person who documented this is Mark Galanter, and the study is called The Vanishing Trial, published in the Journal of Empirical Legal Studies in 2004. He went through decades of federal and state court records and counted. Here is the finding in the article's own words. The portion of federal civil cases resolved by trial fell from 11.5% in 1962 to 1.8% in 2002, continuing a long historic decline. And then the sentence people skip past, also verbatim. More startling was the 60% decline in the absolute number of trials since the mid-1980s. Rate those two together because they do different work. The first is a rate. Better than 1 civil case in 9 reached a trial in 1962. By 2002, it was fewer than 1 in 50. The second is a raw headcount, and it is the one that should stop you. Federal civil filings grew enormously across that period. The number of actual trials went down anyway. More lawsuits, fewer trials, and it did not stop in 2002. Writing in Judicature, the journal published by Duke Law School, Jeffrey Smith and Grant McQueen, carried the same series forward out of the annual reports of the Administrative Office of the United States Courts. In 2016, out of 271,000 civil cases terminated in the federal district courts, 1,965 ended in a jury trial and 816 in a bench trial, about 1%. And they note the absolute number of civil trials in the district courts is now lower than at any point in the preceding 55 years. For scale, they also give you the starting line. When the Federal Rules of Civil Procedure were written in 1938, roughly 20% of civil cases were resolved by trial. Now, I want to be careful about what those numbers are, because this show cares about the difference. Those are counts. They are empirical work on court records, not a rule anybody announced. No court ever held that civil juries should be rare. There's no opinion to overrule, no doctrine to argue with, nothing to appeal. But look at what they do to everything else we have said today. Well, like yourself, the Seventh Amendment promises that in a suit at common law you get a jury. Bombolis confines that promise to federal court. Colgrove lets the jury be 6 instead of 12. The $20 line sits buried under a statutory threshold more than 3,000 times its size. And now, in the one forum where the amendment applies with full force, the proceeding it guarantees happens in roughly 1 case out of 100. The causes are ordinary and mostly nobody's fault in particular. Cases settle because trials are ruinously expensive and slow. Judges resolve claims before trial on the papers. Arbitration clauses buried in contracts root entire categories of dispute out of court before a dispute even exists. Not one of those is an attack on the jury right. Each one is a rational person doing the sensible thing. Which is exactly why it belongs in this episode rather than in a different one. The Seventh Amendment is the clearest case study in the Bill of Rights of a guarantee that erodes without anyone eroding it. The words did not change. The court did not overrule it. The country never voted it down. It simply became one economically sensible decision at a time, a promise about a procedure that almost nobody uses. A right you hold and never exercise is still a right. It is just no longer, in any practical sense, the thing the founding generation was arguing about. Here is the thesis, and it is a precise one. The Seventh Amendment reads like one of the most concrete guarantees in the entire Bill of Rights. It goes so far as to name an actual dollar figure, and yet almost every concrete thing about it has quietly given way. The specific right, trial by jury, turns out not to bind the state courts where most civil disputes are actually decided. Bombolis says the amendment does not in any manner whatever govern or regulate trials by jury in state courts. The specific jury, the common law 12, has been read down to 6, Colgrove says. A jury of 6 satisfies the Seventh Amendment's guarantee. And the specific number $20 is not a threshold anyone ever has to clear, because the statutory gate into federal court stands far above it. A precise-sounding text has become a federal-only default, carrying a jury the court felt free to resize and a figure that controls nothing. Right, and notice what is the eroding here, because it is the real lesson of the Seventh. Nobody repealed the civil jury right. There was no repealing amendment, no dramatic overruling, no moment where the country voted the guarantee down. The words of the Seventh Amendment today are exactly the words that were ratified in 1791. That is the whole point. It is the same fixed text wearing away against 2 centuries of a changing economy, an expanding and independent role for the states, a court willing to read the word jury by its function rather than its historical shape, and a Congress that set the real entry price by ordinary statute. The Seventh is a case study in how a constitutional provision can age without ever being amended. The letters stay exactly where they are on the page while the meaning underneath them quietly migrates. What looks, in print, like a sharp, numbered promise operates, in practice, as a soft, partial federal default. That is the sample. A full Amendment 7 season on this show would take each piece in turn, the civil jury clause and the vanishing trial, the reality that even where the right is at its strongest, in federal court, most civil cases now settle or are decided by a judge and never see a jury at all, the re-examination clause and the genuine question of how much room a judge really has to override a verdict, the jurisdictional statutes, and how the amount in controversy requirement has moved over time and the incorporation gap itself. The puzzle of why this right, almost alone in the Bill of Rights, still stops at the federal courthouse door. One doctrinal question per episode, each anchored in cases we verify, not remember. A quick word on how this show works. Everything you just heard is legal education, not legal advice. We are teaching how the doctrine moves, not telling you what to do if you are ever the party standing in that lawsuit. And we are careful about the difference between our sources. Bombolis and Colgrove are court holdings, pulled from the court's own opinions before I wrote a single word. The $75,000 diversity threshold and the absence of any minimum in federal question cases are statutes. Congress's work, not the courts, and I have called them that. Every citation is in the show notes. That is the whole ethos, and it is the name of the show. Do it for the case law. I'll see you at the next amendment.